Hi, in this video I'm going to explain the changes to the immigration rules and how these affect the sole representative route, or representative of an overseas business visa as it's known. So this is an important means of coming into the UK to set up a branch or subsidiary of an overseas business. And I speak about it a lot on this channel, and there's several videos covering it on this channel. Now, these changes are coming up in the statement of changes to the immigration rules, which are going to take effect from the 4th of June of this year. Now, the first major change that I want to highlight is the requirement in relation to majority control. So it was a requirement under the rules, and I've just highlighted it here, that you cannot be a majority shareholder in the overseas business. But what they've done now is change that. This is going forward for future applications from the 4th of June, to say that you've got to, not only should you not be a majority shareholder, but you should not have a majority stake in the business or otherwise own or control the overseas business. And that can either be through a shareholding or any other arrangement. And it's sometimes the case in certain countries in the Middle East, or in Qatar, for example, is one country where you need to have a local person who's the director or owner of the company. And then you might have a side contract relating to the control of the business. So basically any such arrangements would need to be disclosed, and you would not qualify for the sole representative visa if, through some arrangement other than a direct shareholding, you in fact controlled the business, you owned or controlled the business. So they've strengthened up that provision, but it's also the case that sometimes people reduce their shareholding in order to qualify under the rules, and that has always been quite difficult, because if you just have a look at this provision, you've got to provide a full description of the company's activities, including details of the company's assets and accounts and the company's share distribution for the previous year. So if you've recently changed the shareholding or share distribution, then that will be apparent from the previous documents that you submit for the earlier year. So that's always been difficult, but they have strengthened that now through the amendment that I've just explained. Now, the other important requirement is this, and it relates to spouses or partners. So I do speak to people, typically but not always men, whose wives have some role in the business. And what you can't do now is make your spouse, partner, or same-sex partner, but typically in the examples I've dealt with, your wife, you can't gift her shares in the business and then have her apply, so that you're on a dependent application. And you could see why this thought might occur to people. On a dependent visa, you're not restricted in terms of your work in the UK or the business that you engage in the UK. So there may be a temptation to gift it to someone who's close and trusted. So that might be your spouse, where they apply as the main applicant if they've been involved in the business. But they've specifically introduced a provision which would have the effect of preventing that, where the result of it is that your spouse and you would have control of the business. And I'll just bring up the provision here, so you can see that this says, and this is in the requirements for partners. I can take you to the main requirements in a minute, but it says where the applicant, that's as I say, your spouse, your wife, let's say in this example, is accompanying or joining you and you've been granted entry clearance or leave to remain under the sole representative category, the applicant does not have a majority stake in or otherwise control the overseas business, whether that ownership or control is by means of a shareholding, partnership agreement, sole proprietorship, or any other arrangement. So this would mean that your spouse wouldn't be able to have majority shares in the business. So you can redistribute the shares between you and your wife, so that your wife had the majority shares in the business and you had the minority shares. And the other point is that if there was a standalone a dependent application, then your spouse in their own right could not have majority shares in the business. So it's conceivable that you could still apply where each of you had minority shares. This is, if your spouse is involved in the business, each of you had minority shares, and cumulatively you did not together have more than majority shares in the business. But there's another point that's come in these amendments, and that's one of genuineness. And there's an express provision now that has the effect that you cannot be applying merely to facilitate immigration objectives, which is quite understandable. So there's got to be genuine business reasons for doing what you're proposing to do. And so I think any arrangement where it involves your spouse may lead to difficulties, because it could trigger at least a consideration of genuineness, of whether your application was genuine or a means of facilitating immigration control. I think if there's been any recent distribution of shares between husband and wife, where one or both of them are applicants, then there's at least a risk of that being deemed to fall foul of the arrangement. So I'll come in a moment to the overview of this route and any other options that you might have, but let's just go on to what the new requirements are now. So as I say, from the 4th of June 2020, there's 3 sets of requirements. Basically, you have to think about the requirements for your, for the overseas business, for the branch or subsidiary you're setting up in the UK, and then requirements for you. So to start with, the requirements for the overseas company, it's got to be an active and trading overseas business, and that's a new requirement, but I suppose it's always been implied in the rules. And you've got to have and continue to have its headquarters and principal place of business outside of the United Kingdom. So that includes through the visa term. So you can't just move the business to the UK and then have your headquarters here. Then you've got to have have no active branch, subsidiary or other representative in the UK before you apply. And then you've got to intend to establish or operate a branch or wholly owned subsidiary in the UK. Next, for the requirements for the branch or subsidiary, it's got to actively trade in the same type of business as the overseas business. And the language here is slightly clearer than under the old rules that referred to the business category, but it's basically type of business. So it's slightly less cryptic now. Next, the branch or subsidiary must not be established for the sole purpose of facilitating entry and stay of the sole representative. So that was my point. It can't be merely to facilitate immigration objectives. And then the intention will need to be to maintain the centre of the operations overseas. Then the requirements in relation to you are that you've been recruited and taken on as an employee outside of the United Kingdom by the overseas parent company, that you're an existing senior employee of the overseas company. So it's difficult if you're just appointed for this purpose. You need to have an employment contract in place. You need to have the skills and experience or knowledge of the overseas business necessary to undertake the role of sole representative of the overseas business in the UK. You need to have the authority to negotiate and take operational decisions on behalf of the overseas business. The intention must be to employ you full-time as the representative of the overseas business, and you mustn't engage in business of your own or represent any other business in the UK. You must not have a majority stake in or otherwise own or control the overseas business. This is the point I was explaining before. You've got to speak and understand English level A1, which is very basic, and I would say that continues to be a advantage of this visa route, is that for some, that the level of English required is very low. That's in speaking and understanding. And then you must be able to accommodate yourself and your dependents. So where does this leave us overall? So I think that sole representative visa is still a great visa route if you are the senior employee of an existing business and you're looking to come overseas. I think where there are tensions or additional considerations that come into play are where, if you're the owner manager of the business, then it can be tricky to come as a sole representative of that business, because you're effectively the prime mover, whereas this visa route is designed for senior employees rather than owner managers. And now, under the new rules, if you restructure things and redistribute shares and everything, then they will look beyond that to see what the substance of the arrangements are, and whether that in fact still means that you have control over the business. Likewise, where spouses are involved, if you involve your spouse in the business, have her apply as the main applicant and you apply as the dependent, that's very difficult to achieve now under the rules. And if things are restructured so that your spouse or wife has more than 50% of the shares, then that would mean that she would not be able to come in as a dependent under this route. So I think one of the continued advantages, though, is the English requirement, which is lower than the other business immigration routes. And comparing this to the innovative visa and startup visas, I did an update in yesterday's live stream, or in my last live stream, where I went over the impact of the statement of changes on the startup and innovative visa. And I would say that if you're in an innovative area of the economy, if you're in tech already, let's say, or you do have an innovative proposal for the UK, then there are significant benefits to a startup or innovative visa. It does, of course, depend on your personal circumstances, so important to take advice on that. If you did want to contact me, I'd be very happy to have a consultation with you. My contact details are in the description below, and feel free to subscribe. I'm going to be going over the other aspects of the statement of changes to the immigration rules and how they affect the exceptional talent provisions in the next live stream. Thank you very much for listening, and I look forward to seeing you in the next video.